You did everything right. You did everything right. You worked hard, bought a beautiful family home in Orange County, and you planned for the future. You even worked with an attorney and put the home into an irrevocable trust to protect it for your children. You thought it was safe, locked away for their future, but it might not be. But what if there was a hidden power you could build into your trust? A powerful but little known role that could legally modify your trust to shield your legacy from financial disaster. Stay with me because we're about to uncover a little known tool in modern estate planning, the trust protector. The trust protector. There's a role inside some trusts that sounds like they can step in and solve just about any problem. They are called a trust protector, an independent third party appointed in a trust document to oversee the trustee and make high-level adjustments to an irrevocable trust, such as amending terms to adapt to law changes, changing trustees, or protecting assets. They provide a safety net for long-term planning, ensuring the grantor's intent remains intact without court involvement. So naturally, families start to wonder if this person has that kind of authority. Could they also step in and protect the property from a Prop 19 reassessment? It's a fair question. In Orange County, where property taxes can jump dramatically after a transfer, that's not a small concern. But here's where I want to ground this conversation the right way. A trust protector can absolutely add flexibility and oversight to a trust, but they do not have the power to override California property tax law. And misunderstandings that distinction is where a lot of well-meaning planning falls apart. If you're navigating an inherited property, working through a trust, or trying to understand what decisions matter most right now, I walk you through these scenarios every week in plain language. Go ahead and subscribe so you don't miss something that could have real financial consequences for your family. A trust protector is an independent third party named inside a trust, most commonly in an irrevocable trust. Their role is to provide a layer of oversight and flexibility that wouldn't otherwise exist once the trust is locked in. Irrevocable trusts are designed to be difficult to change. That's part of what gives them strength for asset protection and long-term planning. But the same rigidity can become a problem years down the road when laws change, family dynamics shift, or circumstances look very different than they did when the trust was created. The trust protector is there to bridge that gap. They're not managing the trust day to day. That's the trustee's role. Instead, they step in at a higher level when something needs to be adjusted or corrected. The easiest way to understand this is with a simple structure. The trustee handles the daily decisions, paying expenses, managing assets, carrying out the instructions of the trust. The beneficiaries are the people who ultimately benefit from these decisions. The trust protector sits above that structure. They're there to make sure the trust continues to operate the way it was intended, even as things evolve over time. If the trustee isn't the right fit anymore, the trust protector can step in and replace them. If a law changes in a way that impacts the trust, they may have the authority to modify certain provisions so the plan still works. It's less about control and more about course correction. Depending on how the trust is written, a trust protector may be able to remove and appoint trustees, amend portions of the trust to reflect changes in tax law, resolve disputes between beneficiaries and the trustee, and in some cases, even shift the governing jurisdiction of the trust, if that becomes beneficial. They can also play a role in protecting assets from outside risks, whether that's a beneficiary going through a divorce, facing creditor issues, or simply not being in a position to manage an inheritance responsibly. All of this adds a layer of protection and flexibility that can be incredibly valuable over time. When someone creates a trust, they're making decisions based on what life looks like at that moment. The challenge is that a trust often needs to function for years, sometimes decades, after that point. During that time, property values change, laws change, relationships evolve, and sometimes the people originally named in the trust are no longer able or willing to serve their roles. A trust protector gives the trust a built-in ability to adapt without having to go back to court. That's really the core purpose. It's a safeguard that helps preserve the original intent of the plan, even when the world around it looks very different. So, a trust protector is mostly used in irrevocable trust. There are a few situations where they might show up in a revocable trust. First, let's talk about incapacity planning. If the person who created the trust, the grantor, becomes incapacitated, meaning they no longer make decisions for themselves. The trust just doesn't run on autopilot. This is where a trust protector can step in. They don't manage the day-to-day like a trustee, but they do provide oversight. They can keep an eye on the trustee, stepping in if someone doesn't feel right, if something doesn't feel right, and make sure the beneficiaries are still being protected the way the trust intended. Think of a trust protector as a built-in safeguard, not the driver, but the person in the passenger seat, making sure everything stays on track when the original decision maker can't step in anymore. Second, let's talk about more complex family and financial situations. This usually comes up in more advanced trust while you're dealing with multi-generational planning or larger estates or blended families. In these cases, a trust protector is often built in from the very beginning. Why? Because once the person who created the trust passes away, that trust typically becomes irrevocable, meaning you can't easily make changes. So instead of scrambling later, the structure is already in place. The trust protector is there from day one, ready to step in if adjustments need to be made, or if something no longer fits the family situation down the road. Third, let's talk about transition planning. Some trusts are written with the understanding that everything works one way today and completely different way later. While the person who created the trust is alive, it's typically revocable. They're in full control. But after they pass, that same trust becomes irrevocable, and suddenly flexibility is limited. So what some planners do is build in a trust protector from the start. During the grantor's lifetime, the role is basically dormant. It just sits there in the background. But once the trust becomes irrevocable, that's when it activates. Now you've got someone in place who can step in, make adjustments if needed, and help the trust adapt to real life changes down the road. The reality is, if you're alive and in control of your revocable trust, you don't need a trust protector. You already have full control. Where this role becomes important is after you're gone, or if you can't act anymore. So here's the big takeaway. When you have a revocable trust, you're in control. You can change it, fix it, adjust it whenever you want. But once that trust becomes irrevocable, control tightens up. Flexibility is limited. And that's exactly where a trust protector starts to matter. They're the built-in way to keep the plan flexible, even after you no longer have the ability to make changes yourself. Now let's bring this back to the question, what's really on people's minds? If a trust protector can adjust the trust and respond to changing laws, does that mean they can step in and prevent property tax reassessment under Prop 19? This is where expectations and reality start to separate. Prop 19 fundamentally changed how property transfers between parents and children are treated in California. Before February 16, 2021, there was a much broader ability to pass property down without triggering a reassessment. That created opportunities for families to hold onto low property tax bases across generations. Today, that benefit is limited, in most cases to a child, to keep a parent's property tax base. The home has to become the child's primary residence, and even then there is a cap on how much value it can be excluded from reassessment. If those conditions aren't met, the property is reassessed to current market value. That's the rule the county assessors is applying. This is the part that needs to be said clearly. A trust protector cannot stop Prop 19. They cannot override the reassessment rule. They cannot override the reassessment rules. They cannot restructure ownership after the fact in a way that avoids these rules. And they cannot change how the county determines whether a transfer qualifies for an exclusion. Property taxes are driven by statutory law and how ownership is transferred and used. The presence of a trust protector doesn't change the analysis. A lot of the confusion comes from the idea that flexibility inside the trust translates into flexibility outside of it. Families assume that if the trust can be adjusted, then outcomes like property tax reassessment can also be adjusted. That was sometimes a reasonable assumption under older rules when planning strategies had more room to work. Under Prop 19, that room is much tighter. The law is very specific about what qualifies and what doesn't. And those criteria are not something a trust protector can modify. That doesn't mean a trust protector isn't valuable. They still can play an important role in helping a trust stay aligned with current laws, making sure the right people are in place to manage it, and addressing issues that come up over time. In some situations, they may be able to help adjust how assets are distributed or managed in a way that supports the beneficiaries more effectively. What they cannot do is change the underlying tax treatment of a property transfer when it comes to Prop 19. This is where I often see families caught off guard. They've done what they thought was the right thing. They created a trust, added layers of protection, and even included a trust protector to make sure everything stayed flexible. Then a parent passes, the property transfers, and suddenly there's a reassessment they didn't expect. At that point, there isn't a mechanism inside the trust that can reverse the outcome. The decision points that mattered happened earlier. How the property was structured, who would receive it, and how it would be used after the transfer. If the goal is to preserve a property's tax base, the focus needs to be on how the property will be handled at the time of the transfer and whether it meets the requirements under current law. That includes understanding occupancy requirements, filing deadlines, and how ownership is structured before and after the transfer. These are the levers that matter, not the presence of a trust protector. A trust protector is a thoughtful addition to a well-designed trust. They provide oversight, flexibility, and a way to adapt to change without court involvement. But when it comes to Prop 19, their role has limits. They help guide the trust, not rewrite the rules that apply to it. If you're looking at a trust right now and trying to understand whether it actually aligns with today's rules, that's a smart place to pause and get clarity. And if this help brings some clarity to a topic that often misunderstood, make sure you subscribe. There are all kinds of details that can make a significant difference for families here in Orange County. And before we wrap it up, if you're in that position right now where you're handling a home after a loss, just know you don't have to figure this out on your own. I'm not an attorney, but I can connect you to one if you need legal guidance. What I specialize in is helping families here in Orange County navigate the property side, the decisions, the timing, and everything that comes with it. So whether you're trying to decide if you should keep the home, rent, or sell it, or you're just not sure what the next step is, I'm here to help you think it through. And if selling does end up being the right move, I can handle the entire process for you, from clean out to closing. You'll find a link below If you'd like to schedule a call, even if it's just to get clarity, I'm happy to help.